another scholarship highlight brought to you by the Center for Firearms Law at Duke University School of Law. This series is a part of the Center's broader efforts to deepen the scholarly discussion of firearms law by engaging directly with some of the many scholars doing productive and innovative work in the area. I'm Jake Charles, Executive Director of the Center, and this week I'm joined by Greg Magarian, the Thomas and Carol Green Professor of Law at Washington University in St. Louis School of Law. We're going to be talking to him about his recent article, Political and Non-Political Speech and Guns, recently published in the William and Mary Bill of Rights Journal. Thanks for being here, Greg.
Thank you for having me, Jake.
Of course. So just in a nutshell, can you tell us a little bit about kind of what the argument of the article is?
Well, the article approaches, first of all, I guess I should take a step back. I've been interested for a long time in linkages and connections and disconnections between the First and Second Amendments. I'm primarily a First Amendment scholar focusing on free speech issues. And several years ago, I got interested in those connections shortly after the Heller and McDonald decisions, wrote an initial law review article about the subject, and then I returned to it in this piece and another one that I recently published actually out of the Center's symposium that's going to come out shortly in Law and Contemporary Problems. So this particular article approaches the First, Second Amendment linkage through the lens of justification. A lot of people on the gun rights side, in the gun rights movement, argue that the Second Amendment should be enforced in a manner essentially like the First Amendment is enforced, and they say that that isn't happening. So that isn't happening part of the argument is one interesting thing to talk about, but the premise that the two amendments should be treated the same way is interesting in and of itself. And I refer to that in the article as the parity premise, the idea that there should be parity between enforcement of the First and Second Amendments. So I set out to examine the parity premise through this lens of justification. How do we justify legally, as a matter of legal and political theory, how do we justify protection for the right to keep and bear arms, protection for the rights of free expression, assembly, speech, petition, and press embodied in the First Amendment. And so I basically go through some possible justifications, and the main organizing principle I use is one that's pretty familiar from First Amendment theory, and that is the distinction between political and non-political justifications. It may be that we can justify protections for free speech, free press, et cetera, on grounds relating to the processes of democracy, political justifications. On the other hand, it may be necessary or it may be possible to justify those protections on non-political grounds, that we are seeking the pursuit of truth in more general terms or human fulfillment. So I sketch out those justifications in the First Amendment setting, and then I try to say, okay, what could be the parallel justifications in the Second Amendment setting? And I assume we'll talk about that more as we go along, but the punchline ultimately is the justifications don't line up. And so using this way of looking at the First and Second Amendments together, we can see real problems with the parity premise and real reasons why it might not make sense for courts to treat the First and Second Amendments the same way.
Yeah, and so you mentioned that you're coming to this as a First Amendment scholar, and you got interested in the topic around the time of Heller, shortly thereafter. What brought you to write this article? What was kind of the impetus for it?
Well, really, I've since writing, the first article was back in 2012 in the Texas Law Review. And as this issue has become more interesting, but I think it's been interesting all along, but it's become more interest to greater number of people. And I've continued to think about it. I've gotten motivated to turn this into a book project. I think there's an awful lot to say about the First and Second Amendments. And so I've had a couple of opportunities through symposium discussions to develop different aspects of the idea. I talked in the Texas article to some extent about justification, and I wanted to go deeper into that. I felt like, I think everything in that article, it's 8 years old now. I think there are some valid observations there, but there's also a lot that I've rethought and a lot that I need to think more deeply about. And so this was really an opportunity to dig more deeply into that question of justification as one part of a larger project that has theoretical dimensions, practical dimensions, a lot of different angles to it. So I'm just trying to bite off pieces as I go along.
Yeah. So kind of as a continuation of your own scholarship, who else or what other kind of literature or scholarship do you see this as joining or as hoping to change kind of going forward?
Well, I can answer that question on a number of levels. Most directly, the two people probably whose scholarship in this particular area I most admire and most seek to emulate and speak to are, this is going to sound gratuitous, but the two guys who direct your center. Daryl Miller and Joseph Locher have done amazing and thoughtful work on connections between the First and Second Amendments. And so in approaching this stuff, I really start with them. Beyond that, more generally, I think what I'm really continuing constantly to address in this series of projects is the people both in academia and on the judicial side, on the policy side, who are talking about exploring and especially promoting this parity premise. So there are a lot of folks, it's almost axiomatic in gun rights promoting scholarship and advocacy to make these arguments about how we need to be treating the Second Amendment just like we treat the First Amendment. I dare say on the more pro-regulation side, which I think it's fair to associate Joseph and Daryl with, the examination of that idea has gotten a lot more nuanced, and I'm trying to get more nuance along with it. The gun rights side, I don't think it's gotten very nuanced. So if I'm trying to make, in scholarly lingo, an intervention here, I think the intervention I'm trying to make is primarily to upset that narrative about how, oh yeah, certainly we should be treating these two amendments the same way. On the pro-regulation side, the thing that I think the way in which I differ a little bit from cooler heads, perhaps like the heads of Joseph and Daryl, is that most people writing about this stuff, and those two are exemplary in this regard, are sort of accepting the primacy of Heller and McDonald, saying, okay, these decisions are done. Either they're rightly decided or we're not going to argue right now about whether or not they're rightly decided. Let's move on from that and try to be the adults in the room. I'm not so much being the adult in that particular room. I'm a little bit more inclined to continue the argument about whether Heller and McDonald were properly decided, which I don't think they were. And I mean no criticism or disrespect to people who are taking the more level-headed approach, but somebody's got to, I think, keep this front of the battle open, and I'm one of the people who's doing that.
That makes a lot of sense. And so one thing kind of you talked about at the beginning here, and you talk about to preface your article, is that really a lot of the work of fleshing out a new doctrine is determining this justification or the purpose or the value of the right and what it's serving, so we can kind of extend it to reach the things that it's justifying and not extend it further than that. Why do you think there really hasn't been a lot of consensus around the Second Amendment's animating value or justification?
Well, I think Heller, the Supreme Court in Heller, set out in part to short circuit that discussion or to end that discussion. And the Supreme Court being the Supreme Court, I think as a judicial matter, they have managed to do that for the time being. I think when the Supreme Court says, look, there's nothing more to say about how and why we justify Second Amendment rights, other lower courts certainly are going to follow suit and say, okay, you said it, God's word to our ear, we move forward under that view. On the scholarly side, this goes to what I was saying a moment ago. I think to discuss justification really does entail going back to Heller and questioning the underpinnings of Heller. And I think most people in the academic gun rights debate, for a wide variety of reasons, don't want to do that much right now. So the discussion of justification is, I don't mean to suggest that I'm like the only person out there doing this. I'm not the only person out there doing anything, but I think it's not in the foreground of a lot of discussions right now. But if you have questions or doubts about Heller, as I certainly do, then I think the question of justification becomes quite urgent. I think Heller did its work very poorly in trying to settle the justification for Second Amendment rights. And to the extent Heller contributed anything of value, I think it opened doors that are well worth walking through and exploring in greater depth.
Yeah, that makes a lot of sense. So kind of returning to this this notion of parity, and you mentioned that it's a claim that we see a lot in advocacy for gun rights, is that, and you mentioned kind of there's two claims there, right? The one is that it should be treated like other rights, like the First Amendment, say, and that it's not being treated that way. And there's been some work on it's not been treated that way, trying to show, or trying to discuss whether or not it's true. In fact, the courts are treating the Second Amendment differently. And you're attacking kind of the other premise, which is that it should be treated similarly, at least to this amendment. And I'm interested in your thoughts on why you think that it's so often the First Amendment that's used by especially the gun rights advocates to want to say you should treat it like this right in particular.
Yeah, well, there start out being, I think, some very good and understandable reasons for the linkage. If you think about the tapestry of constitutional rights under the Bill of Rights, the incidence of what are often called substantive rights is relatively limited. So a lot of the Bill of Rights is concerned with procedural rights, due process, criminal procedure protections. And then the Equal Protection Clause is maybe the single biggest doctrinal innovation to come in through the Reconstruction Amendments. And the Equal Protection Clause doesn't deal with guaranteeing any particular substantive right in absolute or concrete terms. It's about comparison. If one group of people gets treated one way, other groups of people have to be treated the same way. So when the Second Amendment comes along, it's a substantive right. The government shall not infringe the right to keep and bear arms. And the most obvious and rich template for that type of right is the First Amendment. The only other real possibility is substantive due process, and that's a very different kind of doctrine, for starters, because it's not particularly textually grounded in the way that the First and Second Amendments are, at least in the way the Second Amendment is according to Heller. So it makes a lot of sense to say, okay, we've got this new substantive right. Let's look to the body of law that has most richly developed a doctrine for protecting a substantive right. That's the point at which I think the good reasons for comparing the two rights kind of runs out of gas. And you can do a lot with that. You can say, okay, we need standards of review. Okay, we need to think about, if this is a substantive rights protection, we need to think about circumstances in which there are exceptions to that substantive right. At that level of sort of general formal doctrinal architecture, it's fine and very helpful to talk about these rights together. But then when it gets to saying, well, things like, take a particularly low-hanging fruit example. Okay, the First Amendment says you can't license speech, therefore the Second Amendment should mean you can't license guns. That's the point at which particular developments in First Amendment doctrine get sort of transported wholly by gun rights advocates into the Second Amendment setting. And that's where problems really come up. And so what I'm kind of trying to do with this article is sort of go back to the beginning, reverse engineer it, and say, okay, let's if we're going to talk about these amendments together, let's go to their roots, rather than focus on the branches. Let's talk about similarities or differences between these rights in their fundamental conception, in how we think about them at all.
Yeah, and so one of the differences is the Second Amendment has this preamble that at least many scholars and some judges think that it informs the nature of the right itself. You spend some time critiquing or saying, one, that the preamble actually should influence our thinking about the right, especially about the purposes of the right, and two, that Heller got that wrong, and that some scholars now are getting that wrong as well. Can you talk a little bit about why you think the preamble plays, not just in the question of, does the right protect an individual right unconnected to militia service, but what role the preamble has in the justification of the purpose of the right, and where you think Heller went wrong on that? Sure.
Well, I think this is the most fundamental mistake of Heller. I think the preamble is terribly important. The first thought that I ever actually had about how the First and Second Amendment relate to each other, I had been in my work, I've written a lot about justifications for the First Amendment. And when Second Amendment law came into being, essentially the thought that occurred to me when Heller was decided, it was like, you got a perfectly good preamble in this amendment and you just completely wasted it. Man, if we had a preamble in the First Amendment, how helpful would that be? That would resolve all kinds of arguments, or at least inform all kinds of arguments that we spend reams of paper on about why we should protect expressive freedom at all. And here in the Second Amendment, the framers of the amendment laid that out and you just threw it away. That silly thought was really the germ of a lot of what I had to say about this. So the preamble of the Second Amendment clearly says, this is old arguments, I'm treading old ground here, but Heller kind of, scorched this earth. Like, the preamble of the Second Amendment says that the militia is the justification, the predicate for the Second Amendment right to keep and bear arms. And Heller essentially said, preamble is merely descriptive. It merely explains the motivation for the protection of the constitutional right. That has absolutely nothing to do with the scope or substance or nature of the right itself. And I think that's frankly absurd. I think Heller's dismissal of the Second Amendment's preamble is entirely implausible. I think the only reasonable understanding of the preamble is that it is meant to be a substantive anchor, not just explanation, but limitation and frame for the actual Second Amendment individual right to keep and bear arms. And so that requires us to think hard about what the militia clause, the preamble, means. And a lot of excellent historical scholarship has been done on this. My colleague David Koenig at Washington University, a guy who's been very influential on me, David Williams at University of Indiana. But the basic upshot of it is, the best understanding that I've been able to glean from this excellent work that's come before, is that the militia clause is creating and empowering a vehicle for the citizenry to, in necessary or appropriate circumstances, rise up and resist, and if necessary, overthrow a tyrannical national government. That's a big deal. That is a remarkably important thing for the framers of the Bill of Rights to put down in black and white. And I think it's terribly important that we attend to that and treat that as the starting point for the justification of any Second Amendment individual right that we're going to recognize.
So tell me if this is right. I take you to argue that the anti-tyranny rationale was the original rationale and is the justification for the right, but that it shouldn't now guide our development and justification of doctrine. And is that right? And if so, why is that?
I would go even a little bit stronger than shouldn't and say can't. And here's where I mentioned David Williams' work. Here's where he's had a really strong influence on me, because these ideas that I'm about to articulate really come from him. Williams argues that the framers of the Constitution, the framers of the Bill of Rights, that generation, were civic Republicans to their core. And that's something that we acknowledge in a lot of settings. And of course, we venerate the framers of the Bill of Rights. But Williams says something quite audacious and I think quite persuasive. He says that in certain respects, the framers' civic republicanism was quite naive, and particularly as to the Second Amendment. That generation believed that the people as a whole, by which of course they meant the white male property people who held any measure of political power, the people as a whole shared sufficient civic sensibilities that they would achieve a common and mutual understanding of when the national government became tyrannical, and that they would rise up almost organically as one, as a popular force in arms, empowered by the Second Amendment, to overthrow a tyrannical government if such a government developed. And Williams' point is, of course, that's naive. It was naive at the moment it was conceived. It's certainly understandable as naive now. That's not how politics works. Williams has a very, I don't mean to try to represent his whole take on this, because he has a very nuanced and distinctive normative understanding. I'm just trying to pull the descriptive analysis out of his work. But essentially he's saying, of course the people aren't going to rise up as one, certainly not in conditions of our contemporary society. And so the predicate understanding, the whole sensibility behind the militia clause is not operative in present circumstances. If it ever was, we don't have that capacity for common mutual understanding now. Our society is far too diverse, far too pluralistic for such a mechanism ever to gain hold. And that's before we ever start to even talk about some of the more common critiques of the militia clause, like what's the militia, and could we even have a contemporary equivalent to the early Republican militia. So the connection is broken between our social circumstances and the social understandings that gave rise to the Militia Clause. And that's why the justification for Second Amendment rights that the Militia Clause puts in place is just unavailable to us now.
And so one thing you also critique the self-defense justification for the right, and then you present towards the end of the article this conception of an equal right to arms. Can you talk about that alternative conception and maybe how that might cash out in doctrine?
Sure. So let me address, there are kind of two aspects of what you're asking about, and I want to address them both. The first is the critique of the self-defense justification. So in drawing this parallel between justifications for First and Second Amendment rights, I move from the political to the non-political. And I say, okay, we got a political justification for First Amendment rights too. We need to be able to express ourselves in order to bring about political change. That justification works really well for the First Amendment. The insurrectionist justification for the Second Amendment, the Militia Clause justification, that doesn't work so well. So if we're going to justify Second Amendment rights, maybe we need a non-political justification. All right, how does that work on the First Amendment side? We do say that rights of expressive freedom are justified not just on political grounds, but also on grounds most commonly of pursuing truth and individual self-fulfillment. And I try to take apart those First Amendment non-political justifications, and from them I draw a couple of principles. How is the First Amendment normatively setting apart these justifications for free expression and distinguishing speech from all the other stuff, activity, conduct that government may regulate? And I say, well, two things that seem to characterize these non-political justifications for First Amendment rights are what I call the benefit criterion and the equality criterion. Benefit criterion simply means we protect speech and we conceptualize speech in part as a sphere of human activity that across the board in general does more good than harm. That's something that normatively distinguishes speech from protected speech from conduct subject to regulation. And then the equality justification says speech is especially amenable to strong constitutional protection because by and large, not without complication, but by and large, most people share the capacity to speak, to listen, to learn, to use speech as a mechanism for influence, and that's less true in the wide category of conduct action subject to regulation. All right, so basically then I take those criteria over to the Second Amendment side and say the non-political justification for the Second Amendment is individual self-defense. That's what Heller posits. That's what most people in the debate talk about when they talk about why the Second Amendment should protect an individual right to keep and bear arms. Well, do these benefit and equality criteria apply to the right to keep and bear arms? And I argue that they don't, to the individual self-defense justification in particular. I argue that by and large, guns in society do more harm than good. They may do some good in the form of individual self-defense, but they do a lot more harm. And as a broad matter, I don't really understand any gun rights partisans who have argued seriously to the contrary, although the rhetoric often runs the other way. And then it's the equality justification. Gun rights partisans make some very interesting arguments about how guns foster equality. Guns help minorities to protect themselves against majorities. And I take on that argument and I say, look, basically, the only effect of guns in society is that an outnumbered minority becomes an outgunned minority. No minority group, using that term precisely, is going to benefit from a broad rule that says everybody has the right to keep and bear arms. That means your beleaguered minority has that right, but it also means that the hostile majority has that right, and guess what? They've got more guns than you do. So that's my, the critique of the self-defense justification sort of digs in and goes into those theoretical complications a little bit, but the bottom line is pretty simple. You can't parallel this idea of a right of individual self-defense and individual self-defense justification for the right to keep and bear arms with the kinds of non-political justifications that we raised for the First Amendment. All right, the second part of your question, this notion of the equal right to arms. Yeah. One of the things that I've tried to grow up about a little bit in my own Second Amendment work is trying to take the Second Amendment seriously, notwithstanding my strong critiques of it. I think Heller's wrong. I think McDonald's wrong. I don't think a substantive individual right to keep and bear arms is justifiable. But the Second Amendment is there in the Constitution, a concern for arms and the keeping of bearing in arms as an important category of political and social life is present. So can we do anything doctrinally with that that acknowledges the critiques that I'm making, but still gives some role to the right to keep and bear arms? And what I do essentially say, all right, let's parallel this to the fundamental interest branch of equal protection doctrine. Most of what we know of equal protection doctrine is about group identity, racial discrimination, sex discrimination. But there's also this somewhat obscure branch of equal protection doctrine, one that's gotten more and more obscure over the past half century, that says certain particular interests, the interest in access to the courts, the interest in access to the political process, certain of those interests are so significant in and of themselves, whether or not we protect them substantively, whether or not we declare absolute protections of access to those interests, those interests shouldn't be available inequitably. So if you're denied the right of access to judicial process, which sometimes means like literally you're denied the ability to get into a courthouse because, say, you're in a wheelchair and the courthouse doesn't have wheelchair ramps, even though you don't belong to a group that equal protection doctrine recognizes as a suspect classification, like a racial minority group or sex distinction, you still have an equal protection right of access to that important interest. And so that's essentially what I say we could do with the Second Amendment. As I think I mentioned before, Second Amendment partisans argue a lot, hey, I say it in the article, gun rights are really important in certain settings for racial minority groups. All right, we can argue about the sociology of that, but certainly if members of a particular group are denied access to guns where other people have access to guns, that could be recognized as problematic. That's something that we should prevent. And so this might, you asked how this might cash out as doctrine. I haven't thought enough about this, but I suggest in the article, maybe this can cash out as doctrine as a way of critiquing certain kinds of rights, certain kinds of gun regulations that would make it harder for people without money to get guns. You know, if there were to be some kind of a special tax levied on guns or ammunition, and it can be shown that that tax was significant enough that poor people couldn't afford it, that it was essentially turning the right of access to guns into an economic class distinction. This notion of an equal right to arms would say, there's something wrong with that. Now, to be very clear, the equal right to arms would leave open the possibility of regulating guns across the board, and that's what my critique suggests should be available. But the equal right to arms would mean that gun regulations would have to be equitable across groups of people in society.
So that kind of brings me to my last question for you. You talk a lot about these issues that you talked about just now, of the intersections between gun rights and gun advocacy and the rationales for the Second Amendment and race in particular. And just given everything going on, the kind of the protests that we see around COVID-related stay-at-home orders, around the unjust killing of George Floyd, and we see guns playing a role in these protests. Just wanted to get your thoughts on if they're kind of what you think the role of theory and justification is doing in the public advocacy and in kind of the public conception of what role arms should play at these protests.
Man, this is so important. And you know, the world has, as always happens, gotten way beyond what I was thinking about, even to the extent I had a handle on a little corner of it when I wrote this article. But the problem of race and guns has come much more to the fore. And in terms of constitutional theory, a lot of that work can just be done under the Equal Protection Clause and the normal treatment of racial discrimination, or should be done, I guess I would say. But I absolutely think that this moment and this problem, the problem of inequitable enforcement of gun regulations and inequitable allocation of gun rights based on race is something that it's a problem that can really be helpfully informed by going back to the roots and looking at justifications. I think this social moment helps to illustrate to a substantial extent the bankruptcy of a lot of the proffered justifications for gun rights across the board. And I think the racial element of it only underscores that bankruptcy. The notion that We are going to tolerate large mobs of mostly white guys marching with guns into the Michigan State Capitol. If anybody took seriously the insurrectionist justification for the right to keep and bear arms, this deadly, volatile cartoon of Second Amendment insurrectionism should disabuse us of that notion and should show us that, given our contemporary social understandings, that notion is rooted in or at least partakes of some very retrograde ideas about race. And then looking at situations in the wake of the George Floyd protests, you and I were chatting briefly before this discussion. This hasn't really exploded into the foreground of this moment yet, this immediate moment, because so much else is going on and there's so much else to talk about. But there are certainly going to be, and have been already in the background, some instances of Black protesters in the streets with guns, and law enforcement treating those people very differently than it treats white people with guns in roughly similar settings. And I do think that particular problem helps to show, maybe it allows for my notion of the equal right to arms to at least resonate a little bit with the situation in our actual social civic life.
Yeah, well, thanks for those parting thoughts. Really timely and important. And thanks for joining me for the discussion today. I had a great time chatting with you and learning more about this article and how it came about and the ways that it can play out in real Second Amendment doctrine that's being developed currently. So thanks for being here.
I really appreciate the opportunity to talk about this, and thank you, and thanks for all the work that the center is doing on moving this debate forward.
Appreciate that. And thanks to all of you for joining us at home. Please follow along in this series on scholarship highlights on recent literature in the Second Amendment area. And follow us on Twitter at Duke Firearms Law, and visit our website at firearmslaw.duke.edu. Thanks very much.